Afternoon, everyone. The appearance before the Commission on Judicial Performance and inquiry concerning Justice Jeffrey Johnson is now in session. Chairperson Nancy E. Nishimura is presiding.
Thank you. Good afternoon. This proceeding is the appearance in the inquiry concerning Justice Jeffrey W. Johnson. I am Nancy E. Nishimura, Chairperson of the Commission on Judicial Performance. Commission member Dr. Michael Moodian is also present in the courtroom with me. And all of the remaining commission members are present by video except Ms. Sarah Kruger-Yeager and Honorable Lisa B. Lynch, who are recused. Any member of the commission may ask questions during this proceeding. Members will raise their hands if they have a question and wait until I'm able to call on them before they speak. We are conducting this proceeding using remote technology due to the COVID-19 public health crisis and the need to respect social distancing in the courtroom. Because of social distancing requirements, the public may not be physically present in the courtroom, but may watch this proceeding by clicking on the live stream link that is now available on the Commission's homepage. The court reporter is also participating remotely by video, and we ask that each speaker enunciate clearly and slowly to allow for any lag time due to the video transmission and to assist the court reporter with transcription so that the record of this proceeding is accurate. Masks must be worn during this proceeding due to the public health crisis. Counsel and Justice Johnson may remove their masks only when addressing the Commission. Before we proceed, we want to acknowledge and thank the California Supreme Court for its graciousness in allowing us to use its courtroom for this proceeding. In particular, we want to acknowledge Court Clerk Jorge Navarrete, Principal Attorney to the Chief Justice Neil Gupta, and all of the court's IT staff, especially Michael Durr, all of whom have been so helpful in setting up, testing, and teaching us to use the remote technology today. Respondent Justice Jeffrey W. Johnson of the California Court of Appeal, 2nd Appellate District, Division 1, is present with his counsel, Paul S. Meyer of Costa Mesa. The examiners for the commission are Emma Bradford, Trial Counsel Mark A. Lizarraga, and Assistant Trial Counsel Bradford Batson. This is the time and place duly noticed for oral argument pursuant to Rule 132. Once the argument is concluded and the matter is submitted, the Commission will deliberate in private. The Commission will issue its decision in writing, and it will be served on the parties and will be made public. Pursuant to Rule 136 of the Commission rules, our decision will become final 30 days after it is issued. The respondent has the right to petition the California Supreme Court for review of the Commission's determination. The members of the Commission have received the report of the Special Masters, the transcript of the evidentiary hearing before the Special Masters, and the parties' briefs. In making your arguments, please assume that each commissioner is familiar with the record and the issues presented by the briefs. Please be advised that evidence not previously admitted should not be addressed and will not be considered. Oral argument will last 1 hour. Each side is allotted 30 minutes. Justice Johnson is welcome to address the Commission as part of his 30-minute presentation. The examiner, Emma Bradford, will be heard first. Ms. Bradford will remain at her seat to present argument because the podium is obscured by the video screen. Ms. Bradford, you may proceed. Would you like to reserve time for rebuttal?
I would. Thank you, Chairperson Nishimura. I'd like to request 10 minutes for rebuttal.
Okay.
Thank you, and Good afternoon. As the Commission is now aware, the Special Masters in this case, after hearing the testimony of more than 100 witnesses, determined that Justice Johnson committed not less than 15 acts or series of acts of prejudicial misconduct and 6 acts or series of acts of improper action. They determined that Justice Johnson committed this misconduct over the span of his career as a Court of Appeal Justice, beginning in 2009 when he was first appointed to the 2nd District, and continuing through 2018 when this Commission began its investigation. The Commission found that Justice Johnson's misconduct included engaging in a pattern of conduct towards women that would reasonably be perceived as sexual harassment, including towards colleagues and staff members at the Court of Appeal. That he used the prestige of his judicial office to pursue personal, romantic, or sexual relationships with young female attorneys, that he physically touched some of those women, and that he made vulgar and sexually explicit comments towards others. In aggravation, the Masters also found that Justice Johnson was repeatedly untruthful in his testimony before them, and that he has largely failed to take responsibility for almost all of his misconduct. In light of that record, there can be no other just or appropriate outcome in this proceeding, but that you remove Justice Johnson from office. And I want to focus today on just a couple of issues and factors that most clearly demonstrate the necessity of Justice Johnson's removal. Some of the misconduct in this case was particularly shocking, and that's what grabbed headlines. So you have, for example, the testimony of attorney Roberta Burnett, who testified on the one occasion she ever met Justice Johnson, he, at a dinner, a legal association dinner, he subjected her to a crude, sexually explicit proposition. And you have, for example, the testimony of Justice Johnson's colleague on the 2nd District, Justice Victoria Cheney, who testified that over the span of her career working with Justice Johnson, he subjected her to ongoing comments about her physical appearance, including comments about her nipples, repeatedly touched her breasts and her buttocks, asked her to have an affair with him on more than one occasion, and made a vulgar comment to her at one point that he would kiss and suck her, quote, titties to make her feel better. Justice Cheney and Roberta Burnett are and were experienced professionals, an attorney, a Court of Appeal justice, accomplished in their fields, and they should never have been subjected to that kind of shameful treatment. But to some extent, what is even more concerning than that shocking conduct is Justice Johnson's conduct towards the young women in this case who had recently graduated from law school or who were in the early stages of their careers when they came into contact with Justice Johnson. These were young women who, when they met Justice Johnson, they welcomed the opportunity to establish what they thought was a professional contact with a Court of Appeal justice. And his conduct towards them is particularly concerning because, as the Masters find, it was as to these young women that Justice Johnson exploited his position as a judge for his own personal benefit, that he used his power and position as a Court of Appeal justice to attempt to draw in and impress these women and draw them into an unwanted personal relationship. So if you have, for example, Melanie Palmer. Melanie Palmer, when she first meets Justice Johnson, is a young, recent law school graduate, and she's hoping to get a job at the Los Angeles County District Attorney's Office. And Justice Johnson meets her. He's introduced to her as a Court of Appeal justice, and he finds out about her hopes for getting a job at the LA DA's office. And so he emphasizes his connections to the LA DA, Jackie Lacey, and he makes Melanie Palmer believe that he can help her get a job at the DA's office. And under the guise of a mentorship type of relationship with her, he takes her out to dinner and drinks. And after dinner and drinks, he takes her back to his chambers alone, late in the evening. And she testified that once they got back to the courthouse, to his chambers, that's when things felt different. So when she's alone with Justice Johnson in his chambers, he starts to comment on her physical attractiveness, how attractive her legs are, how fit she is, how beautiful she is. And Melanie Palmer testifies when he makes these comments, and her impression was that he is coming on to her. She got the impression that, and I'm quoting from her testimony, if I were to sleep with him or have some sort of sexual relationship with him, then he would help me get a job and introduce me to Jackie Lacey. That evening, Melanie Palmer manages to extricate herself from the situation. But for months afterwards, Justice Johnson continues to text her with sexually suggestive texts. And Melanie Palmer, at that point, doesn't know what to do. She can't rebuff this Court of Appeal justice's advances because he could blackball her, he could badmouth her to Jackie Lacey that he says he knows so well that he walks his dogs with her in the morning. And Justice Johnson preyed on other young women. Allison Schulman, Price Kent. Price Kent was a young female attorney in her first few years of practicing law when she meets Justice Johnson. And she is up and coming. She's one of the few associates in her firm that's on partner track. And again, she's introduced to Justice Johnson as a Court of Appeal justice and a friend of her law firm's founding partner. And when Justice Johnson meets her, he repeatedly tells her, you should come and meet with me. You should come and visit me at my chambers at the Court of Appeal. Price, I could really help your career. And he tells her that repeatedly. And he tells her law partners to invite her and bring her to an event where he is being honored. And then while they're both at an event for her law firm, after he requests to sit beside her at dinner, she testifies he's leaning in and he tells her again, you've got to come visit me at my chambers. I can really help your career, Price. And then he reaches under the table and he puts his hand on her knee and he starts to move his hand up her thigh. Justice Johnson subjected these young female attorneys to inappropriate and demeaning treatment, and he did so by specifically abusing the privilege that his position as a judge gave him. Justice Johnson's actions towards those young female attorneys, I think, clearly demonstrates why Justice Johnson cannot remain in the position of power and privilege that comes with being a judge, because when he had it, he blatantly abused it. And that goes hand in hand with the negative impact that that kind of abuse of power has on the public of California's perception of the judiciary. That a member of the judiciary would use his status and power as a justice on the Court of Appeal in committing the misconduct is particularly aggravating. I want to focus also very briefly on the master's findings regarding Justice Johnson's alcohol abuse, because Justice Johnson's response to those allegations was particularly telling. The masters found that Justice Johnson committed prejudicial misconduct on numerous occasions when he's observed under the influence of alcohol, both at the courthouse after hours, at legal events, and at private events that he attends as a Court of Appeal justice. Some of the incidents at the courthouse were witnessed by the custodial staff who work there, and the custodians were subpoenaed and required to testify at the hearing. They testified that Justice Johnson would come back to the courthouse late at night, smelling of alcohol, drunk, slurring his words, sometimes bringing young women back to the courthouse with him, and as to one custodian, asking that custodian on more than one occasion if he wanted to party with Justice Johnson. One of the custodial staff testified she was so concerned about Justice Johnson because she saw him outside of the Court of Appeal, barely able to walk straight, that she pulls over and watches to make sure he gets into the Court of Appeal building safe. And she calls her supervisor to ask, should I do anything? Justice Johnson's out here and he can't walk. He's so drunk. First of all, the masters made a finding that those custodians had absolutely no reason to lie about what they saw. And they also described those custodians variously as particularly respectful of Justice Johnson. They found that the custodians limited their testimony to very specific recollections and didn't attempt to embellish their observations. Justice Johnson's response to that testimony was this, and I'm quoting, "Every witness who said they saw me in the Court of Appeal building, drunk or intoxicated, is testifying falsely." And then he went on to accuse the custodial staff of, at least some of them, of racism and racial stereotyping. Not just that the custodial staff might be mistaken or wrong, misremembered, but that they were testifying falsely under oath. And the masters also found that Justice Johnson committed some of his most serious misconduct while likely under the influence of alcohol, including the conduct perpetrated against Roberta Burnett, Price Kent, Alison Schulman, and some of the conduct towards Justice Cheney. And they also found that Justice Johnson became so drunk at the reception of a wedding that he had earlier performed that he became belligerent, got into an argument with a member of staff for the venue, and had to be escorted out of the venue by the groomsmen. Despite all of that testimony, despite the testimony of his friends, fellow judges, and custodial staff who have no imaginable reason to lie or axe to grind with Justice Johnson, his response to all of those charges is a flat denial. It didn't happen. I was never drunk. I was never intoxicated. And this wasn't the first time that Justice Johnson had been warned about problems with alcohol. The testimony at the trial from his sometime friend, sometime attorney, Eric George, was that he had been warned, look, there's rumors going around about you being in bars, being 86 from a bar because you were drunk and pinched a waitress's buttocks. And there was testimony at the trial that former Justice Dempsey Klein had also warned Justice Johnson, look, there's rumors going around that you go to bars, you get drunk, and you pick up women. Justice Johnson didn't stop then, and he continues to deny that he has a problem with alcohol. The protection of the public is one of the standards which guides this commission's decision. And the commission in Pratt noted that that standard, protecting the public, prompts a question. And that question is the judge likely to again engage in misconduct? Justice Johnson's denial that he committed any misconduct related to alcohol or while under the influence of alcohol is one of the most telling factors, most telling indicators that there is a very real likelihood that Justice Johnson will again engage in misconduct. Because Justice Johnson has not and will not admit that he has a problem. And he has produced no evidence to this commission that he's received any treatment or taken any steps to deal with what the masters described as an apparent untreated alcohol abuse problem. If a judge doesn't admit their misconduct and take the necessary steps to correct and to reform their conduct, how can this commission have any confidence that he will not again engage in misconduct? outside of the actual misconduct that the masters found Justice Johnson committed. One of the most significant factors that this commission has to evaluate in deciding the appropriate discipline is Justice Johnson's honesty or lack of it. And the Supreme Court language in Klepfer is often noted in commission's decision, and that is the language that honesty is a minimum requirement of every judge. Justice Johnson has failed even this minimum basic requirement. The masters, after hearing all of the witnesses, found that Justice Johnson was not truthful on multiple occasions. And it wasn't just that they found that testimony was not corroborated or that it was a close call, that one witness was more credible than another. They found that Justice Johnson gave false testimony at the proceeding. For example, with regard to count 1, and that's the charges involving his misconduct towards Justice Cheney. The masters found that at various points during his testimony regarding that conduct, Justice Johnson displayed not only a, quote, lack of candor, but that he made intentional misrepresentations, that his testimony was, quote, untruthful, and that his testimony reflected a failure to tell the truth. And on count 5, the conduct regarding Tricia Velez, one of the court staff members at the court trial, the masters found that Justice Johnson was not just not credible, they found that, but that also his testimony reflected, quote, his intentional fabrication of the relevant facts. And that Justice Johnson came up throughout his first response to the commission, then his answer, and then his testimony at the hearing, that he came up with evolving descriptions of his interactions with Ms. Velez and was being untruthful in doing so, attempting to posit an innocent but false context for his remarks to Tricia Velez. Justice Johnson lied in response to this commission's investigation. He lied under oath during his testimony before the masters, and he continues to lie in his submissions to this commission. The commission cannot fulfill its mandate to maintain public confidence in the integrity of our judges if it allows Justice Johnson to continue on the bench after 3 of his fellow jurists found that he lied repeatedly under oath.
Counsel, 2 minutes.
Thank you. The Supreme Court in Adams versus the Commission on Judicial Performance stated, there are fewer judicial actions that provide greater justification for removal from office than the action of a judge deliberately providing false information to the commission in the course of its investigation. A judge who engages in the kind of blatant misconduct that Justice Johnson was found to have committed and then lied about it under oath is not someone that can or should be entrusted with one of the highest positions of power and authority in our state. Thank you.
Mr. Moore.
Good afternoon. When the commission originally charged Justice Johnson with willful misconduct, a word you did not hear from the examiner during her argument just a moment ago, when you charged him originally with willful misconduct and with this gross CHP officer claim and with allegations that did not limit Justice Cheney's credibility, and with the single 2009 and 2015 incidents just described, and then included a load of social comments, as a commission, you had no choice but to file formal proceedings leading to removal. We understand that. And Justice Johnson had no choice at that time but to admit it all of it, true or not, or resign. If the commission had not charged willful misconduct, had not charged false CHP claims, if the commission had only charged what is the now limited testimony claims of Justice Cheney, even with the older 2009 allegation and the 2015 incident referring to Ms. Burnett, and all the social comments, which we'll discuss in a moment, we believe, in line with precedent of the commission, for a judicial officer with no prior discipline, no willful misconduct, Justice Johnson would have been offered a censure, something less than removal, and he would have accepted it. We are now full circle. This trial, detailed with over perhaps 200 witnesses and declarations, is concluded. We're now full circle. The trial and concessions by the examiner left the commission with a case with no willful misconduct, with no prior discipline. The CHP claims that originally were so exorbitant in this case, not proved. The masters were very candid about the credibility problems involving Justice Cheney. Even if you ignore the factual problems of the claim of Ms. Price, who produced two different versions of the same event, totally different, and the 2015 claim by Ms. Burnett, which was, we believe, factually disputed by Judge Brazil's version, also in the record, all of that here, based on what has been proved, no more than censure is appropriate, and we ask you to return that decision. There are many red herrings in this case. A number of them were noted in the argument you just heard. The bad publicity from a leaked email about the CHP claims, which has now been debunked, cannot be overstated for the effect that it had on the sentiment regarding Justice Johnson. Lies leaked to a massive audience changed perceptions of Justice Johnson forever, even though those were turned out to be unproved after thorough evaluation by the examiner. We also found, as a red herring here, and you've just heard more about it, piled on claims of less serious social comments over the years. You heard argument about Justice Johnson's outreach to women, young women. They ignored the young men, many of whom testified in this trial, about their careers and the advice and the information and help he provided to them. What you didn't hear was that in all of these social comments regarding Ms. Schulman, Ms. Palmer, other young women, there was no follow-up. There was no proposition by Justice Johnson. You heard in argument just now what one young woman surmised in her own mind after a meeting in chambers with Justice Johnson. Not a word passed Justice Johnson's lips. This was her interpretation of past events after the exposition of the leaked email, after all of the bad publicity. What effect does that have on past interpretations? Now that's taken as fact. We believe that the masters and yourselves as the commission, examining these less serious social contacts of Justice Johnson, do not amount to serious allegations, and in fact, the special masters divided this case into two parts. Serious, which were the allegations they discussed, including the CHP officer and some of the other aggressive allegations, that credibility were now credibility challenged, and less serious social events, and then they lumped in all of these other social comments. Intoxication, please read the record. I know you've gone over that. There's a misleading list of intoxication allegations over a period of 10 years. It sounds like a never-ending litany march of intoxication. How many colleagues, personnel working in the court, people who know Justice Johnson, testified that there was ever any hint of intoxication in any judicial act, in any judicial conduct, in any judicial meeting, in any conference with counsel, in any research conferences? Nothing, nothing. Nothing was claimed by them. Their testimony's in the record. Yet, intoxication, not affecting any case, not affecting any action he ever took as a judge, is alleged. Why is it alleged here? To create an impression. And we submit that when you look through the record carefully, that impression dissipates. It began with the CHP leaked email that cast a pall over everyone. It began with backdoor rumors and behind-the-scenes conversations that are all in the record, admitted by many witnesses, and impression. So when you evaluate, for example, the intoxication, listen to the testimony or review the testimony of all of the colleagues and others who testified. It's their day in and day out observations, and you will find no evidence supporting what the examiner is arguing. They're arguing in this case background created by impression. Justice Johnson is a friendly, sociable person. He's a diabetic. You've got the medical information about that. He always believed we're all equals. When he talks to people, he talks to them one-on-one. He never held himself out as a person who's better than you are. Different than the typical judge profile that people may encounter. Here's a friendly, engaging, sociable person. Has he learned from this process of 2 years of being slammed by rumors and bad press and leaked emails and argument that's based on impression? Absolutely. Social drinking is over. Compliments, his southern customs of reaching out to people and clasping their hand when he speaks to them, totally reformed. These are very painful lessons for Justice Johnson and his family, and they're learned. Stepping back, willful misconduct gets you removed. Prior discipline, which has been ignored, gets you removed. Not the limited evidence which is before you here. If you review Justice Johnson's career, you'll find, as I know you have when you've examined it, fair, unbiased, extremely intelligent. It's reflected in his cases. Ask the LGBT community about his decision of In Re MC, which gave essential parental rights. The legislature adopted that decision. Or his dissent in Sargon. Or many other decisions protecting pensions and all of that. Justice Johnson, undisputed, is brilliant, and it's reflected in his decisions which are recognized. Worthy judicial conduct. Justice Johnson received the Distinguished Service Award in 2017. 2017, after extensive research and investigation. Your past decisions as a commission have not removed a judge without willful misconduct or without ignoring prior discipline. The future for Justice Johnson certainly warrants retention. He's trustworthy. You have a road test here of 2.5 to 3 years of how Justice Johnson has responded to all of the wishes of the administration, working from home, doing his duty, not responding to backdoor politics or the bad press leaks. How has he acted? Reserved, judicial, appropriate. Justice Johnson immediately engaged in voluntary education as soon as he is given notice of an investigation. And the counseling was on all fronts. Social, psychological, educational, and this involved social mores, self-reflection, and it's continued for over 2 years and continues today. The Reformation is clear. Redemption has always been a highly prized factor in decisions by the Commission. In retaining Justice Johnson, you'll find a reformed conduct, same respectful modified behaviors that he's exhibited over the last 2 years. I am very concerned. I'm afraid that Justice Johnson's past conduct will be judged by today's standards. I'm concerned about a huge recent cultural change that's affected politics, it's affected business, new social norms now in play, not years ago.
Well, Mr. Meyer, I have a question. Isn't it true that judges are held to a higher standard on and off the bench?
I'm sorry, I couldn't hear you.
Isn't it true that a judge is held to a higher standard of conduct on and off the bench?
Absolutely. We believe he's met a higher standard. Doesn't mean that a judge is unable to speak friendly in a sociable way, to reach out and communicate with people. You have 100 declarations and witnesses who've testified about Justice Johnson's manner in dealing with people, about his work in the community and what he's done. I mean, but the answer to your question is yes. May I continue?
Please.
All right, thank you. I'd suggest, as members of the commission, that you cross out the allegations that have not been proved, that sit before you. That you look past the allegations that are older than 6 to 8 years, and you look at what remains. Far less serious allegations, far more isolation in the allegations when you look at them, and the piled-on compliments and private casual comments, many built on rumors, many subject to the interpretation of a person who thinks back 5 years later, seeing the atmosphere around them, and then gives an interpretation negative to Justice Johnson. I'm very concerned that the plan, what we believe, since it's formally filed, misleading bulk of less serious charges will blot out the plain fact that their willful misconduct is not here, not found. There's no prior discipline. I'm concerned that the original false allegation that spread like wildfire throughout the entire administration of justice influenced sentiment against Justice Johnson and has now been proved false. We ask you to see Justice Johnson as a person, to respect his humanity, the humanity he's shown in his decisions, shown in his community works. Justice Johnson, who reads to students in elementary schools over years, not seeking recognition, goes out and purchases supplies where needed from schools from his own funds, not seeking any recognition, and the countless men and women who have testified and provided declarations about the Justice Johnson they know. Years of inspiring others. We've had examples from the examiner, and I would suggest you take a look at the letter of Joe Holt, who is a person from downtown, disadvantaged, in a wheelchair with cerebral palsy, who plays chess with Justice Johnson in his chambers on a weekly basis. That's humanity.
Well, question, when did Justice Johnson realize that his conduct towards these women was unacceptable?
When Justice Johnson received the notice of an investigation, Human Resources, he sat back and looked at it and began a process of counseling, of education, of psychological self-reflection.
So prior to that, he thought it was okay?
Prior to that, he interpreted his conduct from his own standpoint. We ask the Commission not to assume that the interpretations which are negative placed on Justice Johnson necessarily accurately relate the facts. Let's talk about the one example that the examiner raised, which is the young woman who met with Justice Johnson in chambers, and he spoke to her. Her recollection was he said, "I had a nice figure," or something like that. They had other discussions, no other comments from Justice Johnson, discussions about her career and what she hopes for, those kinds of things helpful. So the implication from the examiner's argument is that was setting this lady up for further actions and follow-up. We've had many, many, many complaining witnesses testify in this case. There was no follow-up by Justice Johnson. The nature of the...
So you say that if there's no follow-up, that excuses his conduct?
I'm suggesting that his conduct, interpreted in reality and not through a lens of this case necessarily, would reflect that he did have a friendly, sociable conversation with the young woman in chambers.
But as you said, a judge is held to a higher standard on and off the bench, correct?
Yes.
But that was okay with him, is that right?
Are judges permitted to have social, friendly conversations with young people in chambers or in social gatherings or in parties? We submit that they are. And the reason I'm raising it in this way is, along with what the masters found as less serious concerning them, but less serious, we put that, as they did, in that category because this is something that is a social conduct that's subject to interpretation. So our view is, looking at the case now before you in full circle, discipline of no more than censure is appropriate. Justice Johnson has had 2 years of reformation and education. We think in a case here with no willful misconduct, no prior discipline, the precedent would support censure, if you wish, but retention. And I want to turn to Justice Johnson so you can hear directly from him.
Members of the Commission, I am grateful for this opportunity to address you today. I'm here to speak to you from my heart. I know that we only have a short time, and so I won't waste any time replaying or re-engaging the facts. You've seen it all in the papers, in the transcripts, and the evidentiary documents, which speak for themselves. We know that you've carefully considered the master's report, our detailed responses to it, and our careful legal analysis of the examiner's assertions and characterizations. I'm here now to answer your questions. For you to see me for the first time and hear me for the first time. You see me in person. For me to speak to you from my heart, truthfully, as I've always done, and for you to get to know who I am as a human being. I am gratefully ashamed and remorseful for the conduct, that which is true, that I've engaged in that has made some people uncomfortable and brought discredit to the judiciary and to the people of California. This almost 2-year process has been a wake-up call for me. It has shocked me to my core. I accept responsibility for my failings and readily admit them. I made statements out of bounds, and I have never denied that. But please recognize that not all the allegations against me have been found true. I have taken all of this to heart and sought professional help from the very beginning. I've gone through more than 7, now almost 80 sessions with a therapist, a social psychologist, social reeducation, as well as psychiatric counseling. I've taken classes through the University of Pittsburgh on gender in the workplace that has made me more aware of the changing mores in our society and the rights of women in the workplace and the needs to be constantly aware of those and aware of how even offhand comments can interfere with their enjoyment of those rights. And because the findings of the masters have implied an alcohol problem, some of the testimony has implied an alcohol problem, I've enrolled in taking a class through Emory University called The Addicted Brain, which addresses the effect of alcohol and drugs on family situations, work situations, people's perceptions of individuals based on his alcohol, and how that their views of an individual. I'm devastated and humbled by this process and by where I find myself today. I did not resign, and that would have been the much easier course, and many people take that course of action because it would have been construed as admission by me of allegations like those of Officer Sequia, which have now been debunked, and many of Justice Cheney's claims, which the master found not credible and which have been found not true. And what is left deserves discipline, but not removal. The way I relate was too personal. I was raised in the 1960s and 70s in the South. Hugging and compliments to people, especially in the black community, was commonplace. My parents taught me to treat everyone with respect and dignity as a potential friend. This was the way you survived, especially when you were a black person in a segregated community, or a minority in a majority white community. I now see that bringing those traits and habits forward into my life as a judge caused some people to be uncomfortable. I see it now. I believe in equality and humanity. I crossed the line in talking to some people in too informal or familiar manner, and my expressions of warmth and friendliness made some people feel uncomfortable. That's my fault. I didn't see it. That's my responsibility, and I accept that responsibility. I was blind to people seeing me as a figurehead. I should have been aware, but I was so busy trying to be friendly, personable, and accessible to all people without regard to station or status that it didn't occur to me that the person I was caused people to feel uncomfortable or in danger. I deeply regret that I was not more reserved in my interpersonal interactions. I see it now, bright and clear. I need to be, and through my counseling, I have learned to be much more cognizant of how my demeanor affects others. My whole life has been dedicated to eliminating cultural and social barriers. That's undeniable. I've long worked to remove hierarchies in our society. I wanted to be a person, a lawyer, a judge, who came from and was one of the people that he represented. That was always so important to me.
Excuse me, Your Honor, question.
Yes, ma'am?
How long have you served on the Court of Appeals?
Now it's 9 years, ma'am.
And prior to that, were you also serving on the bench?
Excuse me?
Were you also serving on the bench prior to?
Yes, ma'am. I served as United States Magistrate Judge
For how long?
for 10 years.
Proceed.
I wanted to be a person, a lawyer and a judge who came from and was one of the people I served. In my heart, and still to this day in my heart, my title does not change my basic humanity whatsoever. Nevertheless, I now realize that I must be exceedingly careful and aware about the effect of my title and position on other people. I can and must do better. I was wrong to assume other people's comfort with me, and I assumed other people's comfort with me. I failed to recognize that age differences, cultural differences, different geographic origins and experiences, and changed mores had altered the way that society perceives me. That failing, again, is my fault exclusively. In the past, my openness benefited me, though. My friendly, outgoing nature helped me to succeed in my primary, college, and law school educations, as well as my career as a lawyer. I now see that my efforts to be the same as everybody else and relate to everyone in that way went too far. And unbeknownst to me at that time, it made some people uncomfortable and some people suspicious of me. There's an old saying that at a certain point, different becomes scary to other people. I think I was different and didn't realize it. I fully realize the need for me to raise my awareness and sensitivity in all aspects of my life to how my words and demeanor impact other people. No matter what happens to me in this process, I welcome the opportunity to be a better person. And if you give me a chance to be a better judge. Toward this end, as you know, I have participated in more than 150 hours of therapy and education. And for more than the past year and a half, I have stopped drinking alcohol altogether. I intend to continue that abstinence going forward. I have never intended my position, or through my position, or title to take advantage of anyone. But I realize that my jocular, frequently too personal nature and social drinking was a cornerstone of how some people perceive me as a human being. I caused some people to see in me negative traits that I failed to see in myself. That's my feeling. I hope there is redemption.
Your Honor, 3 minutes.
I apologize to each person and entity that I've caused to feel uncomfortable, hurt, unsure, or embarrassed. Responsibility rests with me and me alone. At my core, I care deeply about my fellow human beings, and I rarely acknowledge my flaws. You've heard how I read to children, participate in literacy programs, and do other types of volunteer work. To even talk about that in this context is embarrassing to me, because I didn't do it for any accolades. But that shows my care for other people, and that's why I mention it. My informal style and disregard of barriers took my sense of sameness and egalitarianism too far. I have always believed in justice. I remember a night when I was 9 years old, when someone threw a rock through my parents' front window, and yelled the N-word. I remember my dad talking to 2 police officers, one black and one white, who came to our house and were very concerned, deeply offended. After they left, my father could see that my sister and I were very troubled and didn't understand what had gone on. He took us aside and said to us, there will always be people who hold against you traits about you or things about you that you can't control. But if you stand on truth and justice, there will always be those who stand with you. I think it's no small incident coincidence that my sister became a lawyer and I did too. I believe in truth and justice as a lawyer. I believe in it as a magistrate judge and as a justice on the Court of Appeal. I have 3 adult daughters, and I want for them what I want for all women in the workplace and everywhere else, for them to feel safe and secure. I am personally and professionally dedicated to that inalienable right and goal. I am sorry for having fallen short. I believe in justice and equality for all people, and I have faith in the American and Californian commitment to equal justice. I now give myself up freely to your questions.
Dr. Michael Moody has a question.
Thank you, Chair. Justice, thank you for your time today.
Thank you, sir.
You elaborated on an extensive number of hours of therapy and gender in the workplace curriculum
Yes, sir.
that you had enrolled in. Could you just elaborate a little bit more on what you learned based on all of these hours of therapy in school?
And I'm going to allow the answer, and I'm running short of time.
Excuse me, ma'am?
I'm going to allow you to answer the question.
Thank
We're
you.
getting close to time.
I would say the primary thing that I've learned is empathy and understanding. And people come from different backgrounds, and if you go through your life expecting that things that you assume were fine, things that you assume were okay, without taking note of the fact that other people come from different backgrounds, different experiences, different family sufferings and consequences, then you miss the whole point of why we have to be hypersensitive. And I think that a big mistake I made throughout my career is I allowed my staff to call me Jeff. And I wanted to be everybody's friend. And I see that without having that barrier, I lost some of the formality that would have avoided some of these situations. And I see that making comments or asking people questions about their personal lives, for some people, that can be quite intrusive. Whereas for me, it was just the norm to talk about myself and my family, and I didn't recognize the fact that I was encroaching upon their personal feelings. So empathy is the one word that I would say I have learned through this entire process in terms of recognizing other people's needs and feelings and not crossing those barriers.
Thank you, Justice Johnson. Ms. Bradford, you have 10 minutes.
Thank you, Chairperson Nishimura. Justice Johnson is sitting before you today saying he's remorseful. And he's saying he has learned that his problem was being too friendly and wanting to be on the same level as everyone else and wanting to have equality with his staff. What is missing in that? What is missing in Justice Johnson's remorse and acceptance of responsibility and telling you that he has learned empathy? What is missing in that is Justice Johnson's failure to even mention in any way today or take responsibility for the most serious misconduct in this case. Justice Johnson denies and continues to deny all of the allegations regarding Justice Cheney. He continues to deny all of the allegations regarding Jessica Butterick. He continues to deny all of the allegations regarding Tricia Velez. He continues to deny stroking Price Kent's thigh. He continues to deny telling Roberta Burnett that she should, quote, stroke his big black dick. That is what is missing in Justice Johnson's presentation to you today. He can come in and say, I've learned my lesson. I'm not going to be so friendly to my staff. I'm not going to treat people as equals. But what he doesn't get to is the heart of this case, which he continues to deny. And he calls, and his counsel also calls that conduct towards his staff and the other people at the Court of Appeal less serious. Those are less serious allegations. In fact, in their submissions to this commission, they call them less significant or insignificant. They were not insignificant to the women at the other end. They were serious to them. It was significant to Katie Wan and Carolyn Curry and Jessica Butterick and Andrea Blatchford and Tricia Velez, who wanted to come to court, the Court of Appeal every day and do good work and be respected for their good work product and their work ethic. And instead, what they got was having to spend their time wondering what uncomfortable remark Justice Johnson was going to make to them, figure out how to avoid them, figure out how to get away from Justice Johnson without him touching them, how to get out of personal questions. Look at Andrea Blatchford's testimony. She is working for Justice Johnson for less than 5 months when this investigation begins. And she says misconduct is significant enough to her that she avoids going to lunch with him. She avoids being alone with him outside of chambers. She testifies she's on guard, and she's already thinking, after only a few months of working with him, that what am I going to do when this becomes worse, when his behavior becomes more overt, more explicit? Do I confront him? Do I go to HR? It's significant enough to these women. It's significant to Jessica Butterick when she has to figure out, how do I do my job at the Court of Appeal without going near Justice Johnson's chambers? These women deserve a safe and respectful workplace at the 2nd District. And they did not have that. And Justice Johnson can come in and say, I didn't know that what I was doing was wrong. I thought it was okay to say, if I was your husband, I'd never leave your bed. That is not true. It was not true at the time. It was never true, and it is still not true. Those women at the 2nd District deserve a respectful workplace, and they cannot have that if you allow him to return to the bench there. Mr. Meyer talked a little bit about willful misconduct and the fact that Justice Johnson has no prior discipline. I don't think I need to remind the Commission that the last 3 judges who the Commission removed had no prior discipline. With regard to whether this is willful misconduct or prejudicial misconduct, it does not change this Commission's ability to remove Justice Johnson. While it is technically true that the Commission has not prior removed a judge only for prejudicial misconduct, one, the Commission is entirely empowered to do it under Article 6, Section 18 of the Constitution, and the Commission has expressly stated that it would remove a justice or a judge for only prejudicial misconduct. And that's been the Commission's position for over 30 years. In fact, I would quote the Commission's language in Judge Cicero, which is a case somewhat similar to what we have here. And in determining that Judge Cicero committed willful misconduct, the Commission noted, even if Judge Cicero had not been acting in a judicial capacity during his meetings with Tovar and when he handed her the extortion note, so not acting in a judicial capacity, therefore not willful misconduct, the entirety of his conduct warrants removal. A judge may be removed for prejudicial misconduct as well as willful misconduct. And the Commission also noted in the Willoughby case, and I quote, the Commission's reluctance to remove Judge Willoughby from office should not be construed to suggest that the Commission will not in the future remove a judge from office, even for a single act of prejudicial misconduct where warranted. Ladies and gentlemen, this is a case that warrants removal for prejudicial misconduct. Even though Justice Johnson did not commit his misconduct while sitting on the bench, his misconduct is so blatant, affected so many people, was so outrageous, that nothing but removal can protect the public in this situation. Justice Johnson talks about his prior good acts, what he has contributed to society and how far he has come and the good that he has done. And I'm not saying that he hasn't. But
3 minutes, Counsel.
I'm sorry?
3 minutes.
Thank you. Here's what the Commission has said previously. Certain misconduct is so completely at odds with the core qualities and role of a judge that no amount of mitigation can redeem the seriousness of the wrongdoing or obviate the need for removal in order to fulfill our mandate to protect the public, enforce high standards of judicial conduct, and maintain public confidence in the integrity of the judiciary. Ladies and gentlemen, that is this case. Since this Commission began its investigation, Justice Johnson's response has not been to admit his misconduct and seek help. He has exacerbated his misconduct by repeatedly denying that he committed it. He minimizes the conduct that he does admit. He lied under oath, and he accused the women he victimized and other witnesses of lying and of racism. How does the Commission enforce rigorous standards of judicial conduct if it allows Justice Johnson to retain the power and the status his judicial position has given him. Based on this record, only by removing Justice Johnson can the Commission fulfill its mandate and hold California state judges to a standard of conduct that is worthy of the respect and the trust that the public places in them. Thank you.
Justice Johnson, Mr. Meyer, counsel, thank you very much. The matter is submitted.
Thank you.